Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about entrapment. Cases that should have gone to the Supreme Court of Canada, but didn't. In the course of an undercover operation by the police, they set up ads on a website offering sexual services from people who were advertised to be under the age of 18. The purpose of this was to try and see if anybody responded to the advertisements, then set up a meeting with an undercover officer who acted as a go-between or a pimp, effectively, have money exchanged, and then bring them to another room where the supposedly 16-year-old person was waiting to engage in sexual activity, only to be arrested by police in this type of sting operation. And in the course of one of these investigations, an individual was apprehended, and he argued that the setting up of the advertisement on the site amounted to entrapment. When it comes to the law of entrapment in Canada, what is required for police to be able to engage in these types of sting activities is that they have a particularized suspicion related to the activity that's taking place at that place. And when it comes to online activity, it means that site. But this opens a huge can of worms when it comes to police conducting these investigations on the internet. The internet is inherently a dangerous place. There is nothing that would separate any particular site used for communications, social media, or advertising from any other site insofar as how it might pertain to the possibility of people being available and offered for sexual services who are under 18. This is something that the court could have had the opportunity to chime in on, looking at the way in which the law related to entrapment and internet activity developed in a time where we did not conduct almost all of our communication through internet sites, whether it's WhatsApp, whether it's TikTok, whether it's Facebook messages or anything else. And unfortunately, the Supreme Court of Canada really missed the way in which the borders of what should police conduct be and the borders of what entrapment is are becoming widened to allow more and more police conduct because we haven't reined in the way in which our digital society and our digital creations allow the police more opportunities to interfere with our individual liberties and more opportunities potentially for individuals to be entrapped into committing an offense that they otherwise wouldn't have committed, and to permit the police to engage in effectively fishing expeditions for criminal activity. It's unfortunate the Supreme Court of Canada didn't see the significance of this and where people are going in the future as far as their online communications. But hopefully there is a case where the law of entrapment can be reined in to make it very clear and clear boundaries and clear guidelines for police stings taking place on online websites. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bold Creative for putting together these videos. Please like, subscribe, and share with your friends.